Good afternoon and welcome to the House Criminal Justice Committee for March 16th. Madam Clerk, please call the roll.
Representatives Beck, Campbell, Dixie, Doggett, Farmer, Griffey, Hardaway, Hawk, Howell, Halsey, Lamberth, Moody, Russell, Sherrill, Vice Chairman Sexton, Chairman Curcio.
Here.
Mr. Chairman, you have a quorum.
Thank you, Madam Clerk. Members, any personal orders before we get started today? Representative Beck, you're recognized.
Thank you, Mr. Chairman. This afternoon, I'd just like to welcome the 25 for Life Coalition that's with us today in the purple. In the audience, they have traveled from all across the state to advocate for life with parole reform. Thank you guys for coming. Stand up and let us welcome you. Yay!
Thank you, Representative Beck. Thank you all for being here today. We're glad you came to watch us do our work. I have Vice Chairman Sexton. You're recognized.
Thank you, Mr. Chairman. I just wanted to recognize some folks that I met today in my office, and just a real nice family. They were all nice, so I'm not excluding anyone. But Destiny, I asked her what her destiny was, and she said to be a nurse. So she's 18, and she's going to be going to school to become a nurse. So Destiny, would you stand up? And her two sisters are Natasha and Callie. And their mother is Hensley. Did I say that right? Oh, you're Natasha. Okay, I just blew that up. I got Destiny right, though, right? Okay. All right, thank you.
Thank you, Vice Chairman Sexton. Next on my list, I have Chairman Howell. You're recognized.
Thank you, Mr. Chairman. A new friend that I just met a while ago, Mr. David Swinford from Chattanooga. Raise your hand, David. He's from Chattanooga, and I asked him what he did, and he said, I raise cows. So he's a good, hard-working farmer. Make him welcome.
Excellent. Welcome, sir. Thank you for coming. And I also want to introduce Miss Zoe Scott, who's here today. Zoe is from Dixon, Tennessee, where I live, and Zoe is studying criminal justice. And thank you. And we had a plan that Zoe would shadow me today, but I thought that she would get a whole lot more out of shadowing the Department of Safety since she was interested in criminal justice. And so she's kind of done double duty today. So thank you for being here. Appreciate you. The Punxsutawney Phil jokes are coming out. There you go. Members, any other personal orders? Okay, seeing none. Oh, Representative Beck, you're recognized.
I'd like to recognize my shadow for this week.
Again, the Punxsutawney Phil jokes. They're good. Yeah.
There you go.
Yeah, that's right, yeah.
Stanley Davis. He's a junior at FRA here in Nashville.
All right. Welcome. Welcome to you all. I have Representative Hardaway on the list next.
Thank you, Mr. Chairman. I'd like to recognize Stanley Davis's Taylor.
Amen. Yeah. Seeing no other personal orders, we do have a calendar before us today. We are going to jump around just a little bit, so if you could just follow with me, but we're going to run to item number 10, House Bill 1886 by Representative Gillespie. Motion. Sir, you have a motion and a second. I also see you have an amendment coded 14815. Do you wish to move that amendment, sir?
Yes, sir, I would. Thank you, Mr. Chairman.
He moves the amendment, has a second. Sir, you're recognized on the amendment.
So this amendment basically makes the bill. It would just simply change. Well, it makes the bill.
The amendment makes the bill without objection. Let's go ahead and get this amendment on the bill. All those others in favor of attaching amendment coded 14815 to House Bill 1886, please signify by saying aye. Those opposed, you adopt. We're on your bill as amended, sir.
Thank you so much, Mr. Chairman and committee. Again, before you with another problem that I'm trying to address for my community. We have an increasing out-of-control crime problem in the city of Memphis and surrounding areas. And this bill was brought to me by multiple members of law enforcement and community members. And what it would do is if you decide to evade the police department or sheriff's department in a motor vehicle, and you happen to get away from them, but they later find you and can prove that you were in the vehicle, they will be able to seize that vehicle. And with that, I renew my motion.
Members, you've heard the explanation of the bill. I do have Chairman Holsey on the list. You recognize, sir.
Thank you, sponsor, and you and I, or thank you, Chairman. Also, you and I talked about this. Just for the record, they will tie this seizure to a crime. This won't be in any form of a civil issue. All right.
Representative Gillespie.
Thank you, Mr. Chairman. Yes, that is my understanding, and that is yes.
Chairman Holsey, were you satisfied by that answer? If the only reason I ask is if you'd like to go out of session and ask legal services any question you like, we can do that.
We can do that. There's an issue with civil forfeiture versus criminal forfeiture, and the way he stated it, he didn't say anything about arresting the guy. He said just taking their property, and I want to make sure that they arrest the guy and it's tied to the crime.
And I think it's a worthwhile question to ask, and so for that, we're going to go out of session to speak with legal services. So we are out of session, and I would recognize Michelle Fogarty from Legal Services.
Michelle Fogarty, Legal Services. The bill says the vehicle must be used in the commission of a violation of the offense of evading arrest, but it provides for civil asset forfeiture, which civil asset forfeiture does not require a conviction for that offense.
Chairman Holsey, do you have further questions for Legal Services? Okay, Leader Lamberth, you recognized.
And I know we use the vernacular of civil asset forfeiture and criminal asset forfeiture, but is it fair to say that under the procedures that are in this bill and in current code, you have to have a nexus between the criminal activity and the assets? In essence, the asset forfeiture procedure that this would follow is the same ones in the code, where the state would have to prove the criminality of the item in order for it to be forfeited. Is that accurate?
Yes. Oh, sorry. Yes, they would have to prove that the vehicle was used in the commission of the offense.
Okay, thank you.
For Legal Services? Oh, all right, members, that's it for Representative Hardaway, you recognize?
Thank you for counsel proving the nexus to criminality and et cetera, et cetera. Does that mean that there has to be a conviction for the forfeiture to occur?
Ms. Fogarty, you are recognized, and if we need to repeat the question, we can.
Yes, please repeat the question.
You and Leader were discussing the nexus between the criminal act and criminality, et cetera. I'm seeking layman's terms. Does that mean that there has to be a criminal conviction in order for the forfeiture process to begin and actually occur?
Under civil asset forfeiture under Title 40, Chapter 33, Part 2, which applies in this bill, there does not have to be a conviction, but the state would have to show that the vehicle was used in the commission of the offense. And I believe that burden of proof is a preponderance of the evidence. So the state would have to show by a preponderance of the evidence that the vehicle was used in the commission of the offense, of an offense.
Representative Hardaway.
Thank you, Chairman. So there would not have to be a conviction at the time of the civil forfeiture or at any other point for the forfeiture to occur.
Ms. Fogarty.
That's correct. That's civil asset forfeiture.
All right. Thank you, ma'am.
Thank you, Representative Hardaway. Next on my list for Legal Services, I have Chairman Russell. You recognize, sir.
Thank you, Chairman. And legal, what happens if a non-owner is the one that's fleeing?
Ms. Fogarty.
A non-owner can file a claim, and I believe there's a process that they have to have a hearing, and they can present evidence that they were unaware that the car was being used for that purpose. There's a whole process for which someone who is the owner of the vehicle to file a claim against the forfeiture. And there's a hearing process.
Chairman Russell.
And that's with the Department of Safety's hearing officer?
Yes.
Thank you.
Thank you, sir. Representative Hardaway, you should be recognized again.
Yes, sir.
Okay, you're recognized.
On the procedure for the owner to appeal where the Department of Safety official presides, is there another path that will take the owner to the courts for appeals of whatever the decision is by the Department of Safety official?
Yes, they can appeal the determination of the administrative law judge.
All right. Thank you, ma'am.
Thank you,
Chairman.
Yes, sir. Thank you. Okay, seeing none others, we're going back into session. Next on my list, I have Chairman Doggett. You're recognized.
Thank you, Mr. Chairman. To the sponsor, the way the bill reads, the original violation, and then they evade seizure. What happens if this case ends up in a circuit court? They have a suppression hearing on the original violation on the stop, and they throw the entire stop out. Is the vehicle returned to this person?
Representative Gillespie.
Thank you, Mr. Chairman. I don't believe so, but I would like to hear from. I don't believe so.
Chairman Doggett.
Would it be possible for, or we don't have to do that according to, I'll defer to that guy over there.
Leader Lamberth, I see your hand was raised.
So, Mr. Chairman, I will say that, again, there are two separate processes. And the example I've given of this in the past, there was a prominent individual from a neighboring county that was prosecuted in Sumner County many years ago, and they were stopped for DUI. And the officer stopped that individual based on crossing the fog line 4 times. And as Chairman, as you're familiar, there was a time kind of in the case law that was not sufficient to cross the fog line 4 different times. Now, to the officer, I mean, he saw this guy weaving down the road, crossing the fog line, he stopped him. Well, this, I should say, formerly prominent individual had a young lady with him who was not his wife, who had been employed to be there, we'll say, and had a large amount of drugs that were with him. And his case eventually was thrown out in the criminal court. His now ex-wife spent a significant amount of time in the civil courts exposing that type of behavior. And so the civil processes do not, the exclusionary rule does not apply to a civil process. And so if someone's criminal case was thrown out because of a bad stop, violating the Fourth Amendment, then the exclusionary rule keeps that evidence from being applied to their criminal case. But if the criminality of the item could still be proven, if it had been utilized in evading an arrest, then I don't think that bad stop would preclude the state from being able to at least pursue trying to prove the criminality of that item. So I don't know if that example makes sense to anybody else, but it's always made a lot of sense to me. Just because something doesn't come into criminal court doesn't mean it can't go into civil court, especially like a divorce proceeding or something of that nature.
Thank you, Leader. Next on my list, I have Representative Griffey. You recognized.
Thank you, Mr. Chairman, and I appreciate the discussion here. And I would simply add that there is legislation pending to try to address civil asset forfeiture in Tennessee. I know a number of members have some consternation that the hearings and resolution on civil asset forfeiture is conducted by the Department of Safety hearing officers and so forth. And I personally advocated that we ought to go to our general sessions and circuit courts so that there's an independent body, right to a jury trial and so forth. What the actual confines of that legislation plays out, I think is up to every member in this body. But to me, this bill is a necessary tool and measure to try to address folks that are using conveyances, vehicles, to engage in criminal behavior, and part of the punishment for that egregious behavior, which is threatening the lives and safety of innocent Tennesseans, should be the possible forfeiture of that conveyance. If you have an innocent bank holder or third party that actually owns the vehicle, there is a process under current law where they can seek to have the vehicle returned to them. There has to be a knowing use of the vehicle by the person for a forfeiture to take place. So I'm in favor of your bill. And thank you, Mr. Chairman, and thank you everybody on the committee for listening to this, my diatribe.
Thank you, sir. Next on the list, I have Vice Chairman Sexton. You recognize?
Thank you, Mr. Chairman. I just have a quick question. If the car belonged to their mother or they had stolen it, if it was a stolen car, would that also be forfeited?
Representative Gillespie.
Thank you, Mr. Chairman. While it's my understanding legally, yes, that would be correct. My understanding with talking to multiple law enforcement sources and other officials, in that scenario, I don't see that happening. I don't see, once the car has been reported stolen, I don't see it going down this path. I would like to believe that, or at least my intent would be for, once that information is realized, that the vehicle would be returned to grandma or a bank, if that's the case.
Vice Chairman Sexton, is that okay? Next on my list, I have Representative Campbell. You recognized?
Thank you, Mr. Chairman. Move previous question.
Previous question has been called. If there's any objection, no objection. All those in favor of sending House Bill 1886 as amended to finance, please signify by saying aye. Those opposed? Sir, the ayes have it. You head to finance. If you wish to be recorded as a no, please let the clerk know. All right, that brings us back to item number 1. House Bill 2184 by Representative Garrett. Patiently waiting. Thank you, sir. And I see that you have an amendment coded 15118. You wish to move that amendment, sir? I do. You have a motion and a second, sir, and it looks like the amendment makes the bill.
It does.
If there's no objection from the committee, we'd go ahead and vote to get this on. So all those in favor of attaching amendment coded 15118 to House Bill 2184, please signify by saying aye. Those opposed, you adopt. We're on the bill as amended, sir. You recognized.
Thank you, Mr. Chairman. This legislation was brought to me by the administration and the Department of Safety. It's an update and it adds clarity to our interlock program that I believe is a successful program. In case you're not familiar with that program, if you are convicted of a DUI offense and you have an interlock device that's attached to your car, you actually have to blow into that device before your car will start. And the amount of folks that actually have this interlock device and it actually prevents them from starting their car and driving drunk, those statistics are very, very high. So with that, Mr. Chairman, I do have Elizabeth Stroker here with the Department of Safety. If there are any questions, she'll be happy to answer those. Otherwise, I ask for passage.
Members, you've heard the explanation of the bill. I have no questions. We're ready to vote. All those in favor of sending House Bill 2184 as amended to GovOps, please signify by saying aye. Those opposed? Sir, you head to GovOps.
Thank you, Mr. Chairman and committee.
Thank you, sir. And we are going to jump to item number 4. I'm sorry, I misspoke. We're going to jump to item number 5 by Chair Lady Littleton. Ma'am, you have a motion and a second. It's House Bill 2236. And I see you do have an amendment coded 13903. Do you wish to move forward with that amendment?
I do.
We have a motion and a second on the amendment. And does the amendment make the bill?
It does.
All right, members, without objection, we're going to vote to get this on the bill. All those in favor of attaching amendment coded 13903 to House Bill 2236, please signify by saying aye. Those opposed, you adopt. We're on the bill as amended, ma'am.
Thank you, Mr. Chairman. I'm going to read this a little bit, and then I'm going to talk a little bit about the bill, if that's
Absolutely.
okay.
Absolutely.
This bill arrived from a year-long finding from the Second Look Commission, a department of the Tennessee Commission on Children and Youth. The commission was created in response to the need to review and improve how the state handles severe child case abuses. We meet along with child counselors, judges, law enforcement, DCS workers, and many others each month and do a deep dive in investigations of these specially chosen cases. The bill I bring today is a result of some issues and roadblocks we found that have resulted in legislation that will help the Department of Children's Services and Commission on Children and Youth to do their job and protect severely abused children. So this bill is the trauma of children who witness abuse or neglect or in traumatic situations. The children do not have to be the alleged victims. The bill changes the definition of child abuse for the purposes of dependency and neglect proceedings. So no one, either the victim or the perpetrator of domestic violence abuse, would be charged with a crime under this new definition. However, DCS could act to protect the child based on a finding of child abuse under the definition if enacted. So we're changing trauma to, if a child witnesses trauma, to child abuse.
Okay. Members, you've heard the explanation. I do have Representative Griffey. You're recognized.
Thank you, Mr. Chairman. Just briefly, I signed on to co-sponsor this bill. We're not charging individuals with a criminal offense for a child that witnesses abuse, but in my experience as a prosecutor, and I'm sure Leader Lambert has, abuse is a learned behavior. And for anybody, any child to have to sit there and watch a spouse abuse another spouse or so forth, that is feeding into the continued cycle of abuse in our family, in our families in Tennessee. And this is a good measure to try to address it. So thank you for bringing it. And thank you, Mr. Chairman.
Thank you, Representative Griffey. Any other questions for the sponsor? Chairman Halsey, you recognized.
Okay, I'm sorry, just so I understand, I thought when I read the introduction to the bill, you're talking about a child viewing abuse of another child. Your example was a child viewing parents arguing or abuse of parents? I'm sorry, I was asking you the question, and part of it was that response. I just want to make sure I'm reading the bill right.
Chair Leah Littleton.
I would love to answer that. It is if a child witnesses another child being abused or domestic violence, if they view it and they are a part of it.
Chairman Halsey. Any follow-up? No. Okay. Representative Griffey, you recognized.
Thank you, Mr. Chair. Briefly, again, and this is not a subject of a criminal charge. This is for the juvenile court judge or the chancellor to make a determination whether there is abuse going on in the household such that the state should act to protect that child from the continuing abuse that's going on against another person. So I think it's a smart bill. Thank you.
Thank you, Representative Griffey. I do have a question. We haven't had a chance to talk about this. But in B, you begin with, which I think is the new piece that you're adding. I think A is existing law. It says when the subject child witnesses abuse of another child. I think we all know what you're getting at, but who does subject child refer to legally in this?
It's another child of the immediate family or household.
So it would be, but I guess the subject child would be the child who's being.
The subject child that witnesses, they're all in the same household.
Okay. I just didn't know if we needed to define that some way, but if nobody else has that question, I don't think it's a problem. But Chairman Halsey.
I will be quiet at some point, I promise.
That's okay. I just want to make sure we get it right.
Could I answer your question first?
Oh, sure, please. Yeah.
DCS brought this as a new definition. The amendment came from DCS to help kind of everyone try to understand it.
Okay. Chairman Halsey.
Thank you. I just want to make sure that a child who observes his mom and dad screaming at each other, we're not going to categorize that as child abuse because the child viewed that. You're saying that the abuse, that the parental domestic violence would be such that they could be arrested for it criminally, and if the child observes that, then this is child abuse. Is that what we're saying? I just don't want to go too far down a road here, where we can hang those labels on anybody.
Representative Griffey.
Thank you, Mr. Chairman. So when you get in a domestic abuse situation, there may be multiple children in the family. There may be abuse against a spouse, mom or mom versus dad, whatever, and a child may be witnessing and observing that. And so let's take the situation where there's abuse against one child and there's a sibling, and that sibling is watching the abuse going on to that child. Technically, DCS will not be able to take action against the child that's not necessarily being the focus of the abuse, because that child is not being abused. It's the brother or sister. But this other child that's sitting there watching this, he's having to sit there and watch this and endure this trauma that's going on. This bill will allow the juvenile court judge or the circuit court judge to say, you know, you didn't necessarily abuse child A, but child A sat there and watched you beat the crap out of child B. You're traumatizing child A by your actions. Therefore, I'm going to take child A into the jurisdiction of the court and determine that there may or may not be abuse as to child A, and the court would, may set a parenting plan, try to take remedial measures. This is not criminal. Now, if there is a criminal abuse of a spouse against another spouse or spouse against a child, that is completely separate from what DCS is doing to try to protect a child that is trying to sit there and watch this abuse go on. And without this amendment to the law, the judge really is not going to have jurisdiction to try to protect child A, who is sitting there watching all this abuse and trauma go on, if that makes sense.
Thank you, Representative Griffey. And I think also to your question, Chairman Holsey, because I wanted to make sure we got this right as well, just the example you gave of mom and dad shouting at each other. Married couples get in argument. I hear they get in arguments. It's never happened at my house, but I always just lose. Is what. But so in B, what the chair lady has done is she says, witness domestic abuse as defined in 36.3.601. So if we flip to that definition, I don't think just a run-of-the-mill argument between mom and dad would qualify. But just to make sure we're tight, I want to go out of session and hear the definition of abuse from legal services. So out of session.
Michelle Fogarty, Legal Services. In 36.3.601, abuse is defined as inflicting or attempting to inflict physical injury on an adult or minor by other than accidental means, placing an adult or minor in fear of physical harm, physical restraint, or malicious damage to personal property of the abused party.
Thank you, ma'am. Do you want us to go back in session, back on the bill?
Oh, no, that's
okay.
I'm sorry.
That's okay. Representative Hardaway, you have a question for legal services?
Yes, sir.
Okay, you're recognized, sir.
All of the definition use physical in the description. Is emotional or mental, psychological trauma, is any of that classified anywhere in statute as criminal abuse?
Ms. Fogarty.
Under current law, in what is subdivision 1A of the bill, which is current law, abuse can include physical or mental, sustaining wound, injury, disability, or physical or mental condition caused by brutality, neglect, or other actions or inactions of a parent. So abuse is already defined in current law to include mental abuse, or that would things that would inflict mental injury to a person.
Representative Hardaway.
And that would be a criminal definition, but under this bill, there could be no prosecution for that, though it could be used for the administrative move of putting the child under state supervision. That's what I'm hearing.
That is the definition for the purposes of Title 37, Chapter 1, which covers dependency and neglect actions and abuse allegations, child abuse allegations, child sexual abuse allegations. All of those are covered under Chapter 1 of Title 37.
Representative Hardaway.
All right. Thank you, sir. So under this bill, would there be an opportunity for the abuser of the, we're going to call child A the one that's being directly abused, child B the one being mentally and emotionally abused, would there be an opportunity for child B for there to be criminal charges brought about for being forced to watch and be subjected to the pain, the trauma of watching child A being abused?
Ms. Fogarty.
If it met the elements of the criminal offense of child abuse and child neglect, then I believe, I mean, it depends on the factual circumstances whether or not it meets the elements of that criminal offense. This definition is for the purposes of just Title 37, Chapter 1.
All right, thank you, Mr. Chairman. I think I'm straight in my hat.
Thank you, sir. Members, we'll go back into session. Chair Lady Littleton, you recognize you asked to speak before, sorry.
And just so we do know that some men are abused by their wives, too. Just a taste in there about that. But the intent of this bill is to make sure that all the children, that the families get treatment, even if it is domestic violence, that they get treatment for that with parenting classes and some therapy.
Great. Thank you, Chair Lady, for the bill. Members, there's no one else on the list. I believe we're ready to vote. All those in favor of sending House Bill 2236 to calendar and rules as amended, please signify by saying aye. Aye. Those opposed? Ma'am, you head to calendar and rules.
Thanks for not voting no since I said that.
Thank you.
See ya.
That brings us to item number 6, House Bill 2206 by Chairman Todd. Chairman Todd, you're recognized. Sir, you have a motion and a second. Item number 6.
Thank you, committee.
House
Appreciate the
Bill
motion and second.
2206.
Thank you, sir. And this expands the offense of assault and aggravated assault against a first responder or nurse to include offenses against healthcare facility security guard officers who are discharging or attempting to discharge their official duties. That's all it does. Expands that, adds these folks that are the absolute first responders in those situations.
Thank you for that explanation, sir. I do have Chairman Holsey on my list first. You're recognized.
Thank you, Mr. Chairman. And there's 3 bills like this, and so I am going to argue this with yours and 2 others, but I'm just going to argue it one time, and then I'll shut up. These bills trouble me because we've been doing this. We started off with police and enhancing the penalty if you fight with police. And then we enhanced it to emergency responders. And then we enhanced it to nurses. And now you're a security guard, and you got 2 more bills in here that's to include teachers. And my issue is this. Justice, and that's what we're supposed to be dealing with, criminal justice. In every courtroom, there's a lady with a blindfold over her eyes, and she's got a set of scales that are the scales for justice. And what makes justice righteous and pure is that it's equal. It applies to everybody equally. And I used this illustration before. Yours is for a security guard that works at the hospital. But there's another bill coming today that's for a licensed medical care doctor, because we missed them when we gave it to the nurses. So I use this illustration. If you got a doctor sewing a drunk guy up in the ER, and right beside him is a custodian mopping up the blood, and the drunk guy comes up off the gurney and he punches the doctor in the jaw, and then he punches the custodian in the jaw. Under existing law, he would get a sentence of assault, simple assault on the custodian. He'd probably get a suspended sentence, and he'd get a $300 fine plus court costs, and that'd be it. If we enact this law, when he punches the doctor in the jaw, he gets an increased sentence of 30 days minimum in jail that he has to serve and a $5,000 fine. So what we've said, by law, we have made law that said the doctor's jaw is worth more than the custodian's jaw. It's worth $5,000 more, and it's worth 30 more days in jail. Those kinds of things trouble me because by law, we are saying some people are more important than other people. And that's not what justice is supposed to be. Justice has got a blindfold that says everybody that comes in this system gets the same level playing field. Everybody's equal under the law. I've said for a long time, law gets its righteousness from its equity because we apply it to everybody equally. I have real problems with this, and I understand what you're doing. I really do. I just have real problems. It would be more just to me and more righteous and more constitutional if we just said, anybody who gets assaulted in a medical facility, this is what you get. That way, everybody in the medical facility has equal standing under the law. Or you want teachers in there, then I think Representative Reedy, you got one coming up, then anybody who assaults somebody in an educational facility, this is what you get. You get this enhanced penalty. That way, everybody in the facility is equal, and we're equal under law. And I would much rather do it that way than to separate people and say one person is more important than another person, particularly under law. So that's my objection. You're my friend. There's 2 more bills just like it coming up, so I just argued this one time, but here I am.
Thank you, Chairman Holsey. Representative Todd, you recognized.
I feel honored that I got the brunt for everybody, so I appreciate that, sir. And I don't disagree with you from the standpoint of righteousness and justice. What we have is a law that's been piecemealed together, as you know, and I'm just dealing with the situation at hand. I would certainly accept what you just said as a friendly amendment if we wanted to go that route. I'm sure the fiscal note will change considerably, but I would not be opposed to that, to including anyone in a medical facility to be covered. I just know that these folks, some of which are my friends and yours, are the very first ones that have to show up at the scene when something's going on inside that medical facility. So I would think anyone that needs, you know, the enhanced protection there and enhanced punishment, they would be deserving of that.
Next on my list, I have Representative Griffey.
Thank you, Mr. Chairman, and to my good friend and colleague down there. Your arguments are not invalid or without merit. My analysis of this would be that what we're trying to do is increase punishment when the offense is something that strikes at a core belief or an interest that the person who is injured is not just an ordinary person. They're carrying out a duty or a function that we as a community or a body have asked them to undertake. To me, it's a difference whether the drunk gets up off the gurney and strikes the doctor, or whether the drunk gets up the gurney and goes over and strikes the other drunk on the gurney. It makes a difference to me whether the person, the outraged parent, strikes a teacher at school, or whether the outraged parent strikes another outraged parent that nobody likes in the community. It's always been a horse's patoot at the school. So again, your arguments are not without merit and consideration, but to me, the thing that tips the scales is it's persons in our community who are undertaking a task that the community has asked them to take on, and they deserve special recognition and privilege, so that if someone does an offense against them, it's not just an offense against the person, it's an offense against all of us, and it's an offense against the function and duty we've asked them to undertake. So that's why I respectfully would argue and plead with you to consider, and that's why I'm going to be supporting this bill. So thank you, Mr. Chairman. Thank you to my good friend down there. I love your analysis and your thinking, as always, on so many bills, and it's my honor and privilege to serve with you.
Representative Chairman Todd, you recognized.
Just for clarification, all I'm dealing with is security guard officers. There's no teachers involved in this bill.
Amen. Members, anyone else for the sponsor? Question's been called. All those in favor of sending House Bill 2206 to Finance, please signify by saying aye. Aye. Those opposed? The ayes have it. Sir, you head to Finance.
Thank you.
Thank you. Representative Hardaway, for what purpose? Oh, I'm sorry. Okay, sorry. Thank you. Members, that brings us to item number 7, House Bill 1934 by Vice Chairman Reedy. Vice Chairman Reedy, you recognized. Sir, you have a motion and a second.
Thank you, Mr. Chairman and committee. I guess I should have been standing up here in the well with Chairman Todd and getting part of that lashing out. But I respect you, Chairman Holsey, on that information. And of course, in this, of course, current law 39-13-116 already covers it's first responders and nurses. And yes, I'm here to support our teachers in the classroom, that these teachers share the same building with nurses as well, and thinking they should be just as well protected, Mr. Chairman.
Thank you, Mr. Sponsor. I do see that we have an amendment that's been filed by a member of this committee, a very prominent member of this committee, the vice chairman, or excuse me, the chairman of the subcommittee. Chairman Doggett, do you wish to be recognized and move that amendment?
Yes, Mr. Chairman, thank you for recognizing me on the amendment. What the amendment does is says that students that have an individualized educational program plan, an IEP, would not be affected.
So members, that's amendment coded 15612. Do we have a motion?
That is correct.
Second. Okay, we have a motion and a second, so we're on that amendment, sir. You recognize?
Sure. Yes, sir. Thank you. Sorry about that. Students that have the individualized educational program or IEP plan would not be affected by this legislation. I do know that other members have their thoughts on how this same thing can be achieved, and so if this amendment is open to discussion,
Thank you, Chairman. Thank you, Chairman Doggett. I do have Leader Lamberth, which to be recognized on the amendment. You're recognized.
Thank you, Mr. Chairman. And Chairman Doggett, I like where you're headed with this, but the IEP distinction is relatively broad, in my humble opinion. I mean, to just have a complete carve-out for anybody that has an IEP could potentially, and I don't think this is your intention, but I think could potentially create a defense there for someone who has intentionally attacked a teacher. And I would hate to see that happen. Now, I noticed in the bill as currently drafted that, like many of these other enhancements, it deals with, assault is either intentionally, knowingly, or recklessly. And I think, and please let me know if this is your intent, that the goal here is to make sure that a child who is disabled, that is not able to form the intent to assault someone, would never be prosecuted under this. And I know the sponsor of the bill would never want that either. I think, if you let me know what you think about this, that instead of amending it to include every student that has an IEP, what if we were to increase the mens rea on this particular subset of individuals that have been victimized through assault from knowingly to intentionally? And that's a higher mens rea, and it really would require someone to be able to form the intent to attack that teacher. And if they're not able to form the intent, as some of these children are that are disabled, then they would never be prosecuted. To the sponsor of the amendment, Mr. Chairman, I don't know if that would follow along with what he's trying to do here, but I've only offered it as a suggestion.
Chairman Doggett, you recognize.
Thank you. And my intent with this amendment is something that I really thought that was covered last week, and with the sponsor's intent on the bill is to not go after these children that have IEPs or are part of 504 plans that are in the schools. I've worked in the schools for 2 years in public education and observed a lot of things. And so I know that there are students that have individual needs. There are students that have special abilities and talents that we would want to make sure that they are not singled out. And I think that the sponsor's original, the statement he made last week in the committee was that we were not going after students that fit within these criteria. This amendment was brought to me and asked to be carried to further spell that out. And so it's, I'll refer to the sponsor for his thoughts on this if needed.
Vice Chairman Reedy, you recognize.
Thank you, Mr. Chairman. And that's absolutely correct. Under the current law, there still has to be the intent for the first responder or the nurse for an action to be taken place in a court of law. And so it would be the same thing with, let's go outside of the IEP idea and just a student having coming around a corner, crashing into a teacher. Was their intent to hurt the teacher at that time? No, there was not. And it's the same thing, and I appreciate your heart for the IEP, the special needs students. And actually, my wife and I, we've done respite care for these young individuals as well. And it's interesting, the nonverbals, unintentionally, things happen. And so I appreciate the intent, but I don't think that we need to amend, especially this part of the law, with this amendment. Thank you, Mr. Chairman.
Leader Lamberth, you're recognized.
Mr. Chairman, this is a great back and forth, and I think we have plenty of time left in session to be able to work on this. Before we vote on this particular amendment, it sounds like there's not a lot of daylight between the two gentlemen here that are debating this. Would it be possible, or actually I will tender a motion here to roll this bill 1 week so that we can potentially look at some additional amendments that might be able to accomplish this without being so broad?
That's a proper motion. It has been seconded, so we need to dispense with that motion. All those in favor of the motion, please signify by saying aye.
Aye.
Those opposed? Sir, we roll 1 week.
Thank you, Chairman.
Thank you, sir. Members, that takes us to item number 4, House Bill 2247 by Chairman Vaughn. Motion. Chairman Vaughn, you have a motion and a second. Enthusiastic motion and second.
It's going to take a bit to live up to that, Mr. Chairman.
And Chairman Vaughn, I see that we have an amendment coded 13923. You wish to move that?
Yes, sir.
Sir, you have a motion and a second. The amendment makes the bill. All those in favor of attaching amendment coded 13923 to House Bill 2247, please signify by saying aye. Aye. Those opposed, you adopt. We're on the bill as amended. Leader Lamberth, you're recognized.
Mr. Chairman, the chairman has a wonderful bill here, and I don't want to delay him in any way for this being debated. But, Chairman, there was a very good speech made and a very good point brought up by one of our members earlier on a bill of this nature, and you weren't here for it. And, Mr. Chairman, I wanted to give Chairman Halsey an opportunity, if he wanted to expound on his earlier point.
Tune it back up.
Well, just to tune it back up, because Chairman Vaughn wasn't here for it. And it was a very, very good and detailed explanation of kind of these issues. He may have it written down. Now, Chairman Vaughn may or may not want to hear it. If he doesn't, I totally respect that. And, Mr. Chairman, I will withdraw this idea. But it was a really good speech. So just something for thought.
Chairman Halsey, your name was called.
I won't go over the whole speech, but I would like to add an amendment from the committee that includes legislators.
Out of order. Chairman Vaughn, we are back on your bill as amended, sir. You're recognized.
Thank you, Mr. Chairman. What this bill is in response to is, much like Nashville experienced a tragedy on Christmas Day a few years back, Collierville also experienced a tragedy on September 23rd. We had a mass shooting, which, whenever you hear an active shooter call, your wife calls you and says, hey, don't go to Kroger because there's an active shooter. And you hang up and you go, wait, did she call me from Kroger or what? And you go and you see all these response teams coming in everywhere. No telling how many police cars suspensions were broken coming across railroad tracks. We received shared support from Shelby County, Memphis, everywhere. Anyway, what was really difficult about this is about 3 months before that, we had two great female officers trying to stop somebody, and they got drug under the car. They went, and then when we had suspects present in the emergency room because they had injuries to the suspects, they got physical with nurses in the emergency room. And so the point of this bill is that law enforcement officers, we typically think as the first responders, but actually there's many, many tiers of first responders. And we had firemen, EMTs, breaching Kroger, not knowing what was behind the door. So what we're trying to do here is we're just wanting to provide a little more disincentive to those who want to do evil on the people who are there to do good. That's about the best way I have to say it. And so I understand, hey, I'm a big boy. I understand this fiscal note. It's something that we feel strongly about, my Senate sponsor and I do, because whenever you have basically your community has been violated like that, you get a little bit upset. You get a little bit frustrated. You get a little bit angry. You just really don't know what to do with yourself. And so that's the genesis for this bill. And so that's what I would ask that you all please consider.
Thank you, Chairman Vaughn, and we appreciate that explanation of the bill. I will go ahead and point out, I'm sure you know this, but in case you don't, there are 3 other bills traveling through the system that I imagine will have similar support, and all of them will have fiscal notes, but you all are attempting to get at the same thing. But unfortunately, right now, all 4 of these bills, yours included, conflict with one another. They don't really work that well together. So I would just encourage you, assuming you're successful passing out of this chamber or out of this committee, and then when you get behind the budget, you may want to get together with those other bill sponsors, because I think there's a way to make these all work well together. So I just wanted to suggest that to you. And if you're not aware of those bills, we can get that information to your office.
Thank you, sir. I'll work with your office to get that done. I don't believe that we have a license on good ideas, so we will absolutely talk to those other sponsors and see how we can put those things together.
Great. Thank you very much, sir. Any questions for the sponsor? Representative Beck, you're recognized.
Chairman Vaughn, first of all, thank you for this. I concur with Leader Lambert. This is a fantastic bill. But I also want to thank you for helping legislators not commit malpractice when they're in front of your committee. And you're just a great man and a great human. Thank you so much.
Thank you, sir.
You must have a bill in your committee. Just happened. All right. Members, we're ready to vote. All those in favor of sending House Bill 2247 as amended to finance, please signify by saying aye. Aye. Those opposed? The ayes have it. If you wish to be recorded as a no, please let the clerk know. Thank you, Chairman.
Thank you very much.
Yes, sir.
Appreciate it.
Members, that takes us to item number 8, House Bill 2802 by Vice Chairman Grills. Vice Chairman Grills, you recognized. Sir, you have a motion and a second.
Thank you, Mr. Chairman and committee. This legislation seeks to add electronic tracking devices such as air tags to the current stalking penalties in the code. Last week I told you the story about the little girl back home that realized that she had one placed in her vehicle. She had to move just because of that. She felt like that she potentially could get trafficked. And anyhow, when I got to looking into it, working with the DA's conference, we spent about 5 to 6 weeks working on this with Zoe. The efforts were to make sure that we didn't prohibit parents from being able to follow their children, make sure they knew where their children were, or even an elderly parent that may have Alzheimer's or anything like that. But guardianships and things like that, we just want to make sure we didn't go too far there. But I love that look there, Chairman Doggett. With that, I'll take his question.
Members, you've heard the explanation of the bill, and I do have one member on the list. It's Chairman Doggett. Chairman Doggett, you're recognized.
Thank you, Mr. Chairman. Does it address anything if you wanted to maybe keep tabs on your spouse to make sure that you know where they're at? I know that on my phone has got my iPhone, where's my phone, but I can also link up to hers. So while she's at work, she does home health type services, and sometimes she won't have cell service and will be in different counties, and so I can kind of ping that and see where she's located just for safety purposes, I guess you could say. But would this have any effect on being able to do that?
Chairman Curcio.
Yes, sir, you're recognized.
Thank you. Section B of this, notwithstanding subdivision A1A, includes one instance of placing an electronic tracking device without the consent of a person on the person or in the person's property. I believe your wife would have to go ahead and allow that app to be able for you to track her on her phone. So I think she would have to give you consent in order to follow her in that instance.
Chairman Doggett.
Thank you. No further questions.
Yes, sir. Members, Chairman Russell, you recognized.
Thank you, Chairman. And does the consent have to be in writing or some sort of documentation?
Vice Chairman Grills.
Chairman, thank you for that. I do not know what that, I don't know if you have to have a certified letter saying that you can see it to put that on there or not. I don't think that's the way it works in other instances, but I can't answer that with specificity. Maybe Michelle would.
Chairman Russell?
That's not necessary. I'm going to vote for it anyways.
Okay.
Thank you.
Seeing no other questions, we're ready to vote. All those in favor of sending House Bill 2802 to Finance, please signify by saying aye. Those opposed? Sir, you head to Finance.
Thank you.
Thank you. Moving on to item number 9, House Bill 2043, being carried by Chairman Doggett. You recognize, sir?
Thank you, Mr. Chairman.
Sir, you have a motion and a second.
Yes, sir. There's an amendment, I believe.
Yes, sir. I have amendment coded 14291. Is that the amendment you wish to move?
Yes, sir, that is. Thank you.
Second on the amendment. You have a motion and a second. And the amendment makes the bill, does it not?
Yes, sir, it does.
Members, let's go ahead and vote to get this on. All those in favor of attaching amendment coded 14291 to House Bill 2043, please signify by saying aye. Those opposed, you adopt. We're now on House Bill 2043 as amended, sir. You recognize.
Thank you very much. It adds tyaneptine to the list of Schedule II controlled substances punishable by Class A misdemeanor. It also eliminates the exceptions for Class A misdemeanor for a person to knowingly sell, offer to sell, distribute, or purchase, or possess kratom.
Members, you've heard the explanation. Any questions? Seeing none, we're ready to vote. All those in favor of sending House... yes. Chairman Halsey,
I don't even know what this substance is. Can you just explain that, and then I'll be done.
Chairman Doggett, you recognize.
Yes, sir, I'll be glad to. Thank you for that question. Tyaneptine, and I may not be saying the word correctly, but it has a street name or a label name is Zaza Red. The other sponsor of this bill, Representative Cochran, and I have worked on this. What we're seeing is in our areas, we live in border counties, or at least and I know I do. It's Schedule II in the state of Alabama. It's currently in stores here in Tennessee. We have people that are coming from out of state to come in. They're burglarizing convenience stores. They're being caught with this or being arrested maybe for driving under the influence of this stuff. I've also had a physician tell me that that's here in Nashville that one of the worst cases of detox that they've ever seen was, or withdrawals, was from a person who was on this drug that you could go in and buy in a convenience store. One of the local police chiefs that I have in my district was telling me a story about a gentleman from South Alabama who had vacationed in our great state up in the eastern part of our state and had discovered this drug in a convenience store. On his way back home, he took the drug. His wife had no idea that he had already become addicted to it. He was making multiple trips a week into Tennessee to purchase this drug at convenience stores in my district. When he ran out of money and means to get there, he stole a vehicle and drove to Tennessee and burglarized the store. They caught him, and he sat in jail, and that's where his wife found out that he had an issue. And so we are seeking to remedy this and make it punishable by a misdemeanor. Thank you.
Thank you, Chairman Doggett. And I have Chairman Russell on the list. You recognize, sir.
Thank you, Chairman. And has this drug went through the FDA approval process?
Chairman Doggett, you recognize.
I don't believe it. No, sir, I would not say that it has.
Thank you.
Chairman Russell. Okay.
I may be wrong.
Next on my list, I have Representative Hardaway. You recognized.
Thank you, Mr. Chairman. And Chairman Doggett, looking at the language substantially chemically equivalent, does that take in all of the tricks and the gimmicks where they're trying to change just one or two chemicals and a molecule or so off? So this catches all of those variants?
Yes, sir. That is our intent, that if there is any kind of tweaking that goes on there to the chemical makeup, that it would still fall as long as it's. Sometimes you can alter substances and it creates an entire new substance, but that our intent is to do what you've asked. Yes, sir.
Okay. All right. Thank you. Good bill. Thank you, Chairman.
Thank you, sir. And members, I apologize. I got a little bit of a hurry earlier. We do have two folks on the list to testify on this bill. So without objection, we're going to go out of session. And the first on our list is Dr. Stephen Lloyd, the Chief Medical Officer at Cedar Recovery. Not available. So next on our list, we have Mr. Patrick Powell, the Policy Director for the Tennessee Bureau of Investigations. Sir, you're well known to this committee, but if you could please state your name for the record and then share with this committee whatever you'd like.
Thank you, Chairman. Patrick Powell, Policy Director for the Tennessee Bureau of Investigation. We are supportive of Chairman Doggett and Representative Cochran's bill. Tianeptine is a drug that has been, as he put it, kind of coming on to play in our southern counties after Alabama made it a Schedule II. It's Schedule II also, I believe, in Michigan and Minnesota. Italy has made it a Schedule I. It is highly addictive. Dr. Lloyd is also supportive. He has been treating people for substance withdrawals to the level where he thought he was treating people for heroin withdrawals, and they were only on tianeptine. It is severely addictive. To go back to Chairman Russell's question, FDA has not approved it for any use. So it is significantly dangerous, and we would support making it a Schedule II.
And if you could stay right there, I believe we have a couple of questions for you, sir. First, I have Chairman Hawk. You're recognized.
Thank you, Mr. Chairman. Just reiteration of what Mr. Powell has said. We had a budget hearing yesterday discussing the effects of some of these harmful drugs and creating gateway drugs for other situations. This drug is much more serious. Many folks may remember the bath salts scourge that we dealt with several years ago. This is very similar to that. And to the point of one of my other colleagues that was talking about some of the analogs of these products that are out there now, we're continually like a dog chasing his tail as we're looking at some of these analogs. They're changing a molecule here, changing a molecule there. We're dealing with delta 8s and delta 10s where the THC content is substantially higher than anything we ever anticipated. I'll go back. I was the original sponsor of the legislation in 2017-18. It was initially had kratom as a Schedule II drug, and it got pulled out for really bad reasons. So I'm glad to see this back in there, in addition to some of these salts that people are buying over the counter, thinking they're medically necessary, but again, there's nothing medically necessary about these drugs. It's just a bad way to get a bad high that's causing addictions in many, many ways. So thank you. Thank the sponsor for bringing that. Thank you, Mr. Chairman.
Thank you, Chairman Hawk. Next on my list, I have Chairman Holsey. Chairman Holsey, you're recognized.
Thank you, and I hope you didn't answer this repetitive. What's the method? Is it injected? Is it a pill? Is it a liquid?
I believe they're mostly.
Mr. Powell, you're recognized.
I apologize, Chairman. My understanding is that this is being taken in pill form primarily. Whether or not it's being, cracked open and then melted or injected or smoked, I'm not sure, but I think primarily just pill form.
Chairman Holsey, any follow-up? Okay. Next on my list, I have Chairman Russell.
Thank you, Chairman. And is this a stimulant or a depressant?
Mr. Powell, you recognize.
And I would have to go into the FDA kind of language. I think it's being marketed as an antidepressant in certain circumstances. I think it's attaching to the receptors in the brain similar to opioids, though, creating similar kind of withdrawal effects that, again, as I mentioned with Dr. Lloyd's treatment of some of his patients, that he thought they were heroin withdrawals. So those kind of effects on the brain.
Oh, thank you.
Thank you, sir. Next on my list, I have Representative Griffey. You're recognized.
Thank you, Mr. Chairman. Do we have any idea why the FDA or DEA hasn't acted on this substance? Because it's kind of alarming and concerning that they haven't yet.
Mr. Powell, you're recognized.
And Representative Griffey, I think you brought up that kind of issue previously, and I think I may have even provided you a brief article from the FDA saying that it isn't approved for any purposes, but as far as their crackdown, I mean, there are a number of substances out there that are not approved for any FDA use that are still not made illegal. So it's one of those, they may be in the process now, and of course states are acting. You've got Minnesota, Michigan, Alabama, and hopefully Tennessee. So I don't know that there's not something in the works on the federal level, but obviously the states are beginning to act on that.
Representative Griffey. Okay. Mr. Powell, thank you very much for being here today. We appreciate your testimony. Members, we'll go back into session. We're back into session. And Chairman Doggett, can you address where, because I've heard of the second substance in the bill, but I've not heard of the first. You said this is available just at market, just gas stations, that sort of thing?
Yes, sir. Yeah, you can get it at gas stations or just convenience stores. It's there.
Wow.
Mm-hmm.
Okay. Chairman Russell, you're recognized.
Thank you, Chairman. And do you know what age you can buy this? Is it 18 or 21?
Chairman Doggett.
I cannot answer that. I can't tell you affirmative answer on that, to be honest with you. If a lot of these, you see the weight loss and diet pills that are stimulants that are being sold in the stores as weight loss and diet pills and other different types of supplements or whatever you want to call them that you can purchase. So they may be 18, it may be 21, but I can't give you a definite answer on that.
From my understanding, there's a lot of kids that's getting a hold of this, and regardless of age, we're going to have to do something about it, and I support it. Thank you.
Thank you.
Question's been called on the bill. Without objection, we are ready to vote. All those in favor of sending House Bill 2043 as amended to Finance, please signify by saying aye. Aye. Those opposed? Sir, you head to Finance. Thank you very much. Members, that brings us to item number 2. Item number 2 being carried by Vice Chairman Ogles. It's House Bill 2270. Sir, you have a motion and a second.
Thank you, Chairman, members of the committee. This piece of legislation, excuse me. Chairman, are we running? Is the amendment running with the bill, or do?
Yes, sir. There's no amendment that we need to put on. I believe it was put on in Ag.
Okay. Thank you, Chairman. Members, this bill simply co-mingles BUI and DUI together, one in the water, one on land. So for sentencing, it just brings it over. This body did great work with this the last couple of years in enhancing and creating the BUI. This simply, for the sake of sentencing and enhancement, if you get one in the water, it's going to count against you on land as well, and vice versa. And to Representative Halsey's question, with the sentencing and the background check, the offenses will pop up. I didn't think, when I asked the question, I didn't think we had to do anything else as far as having somebody send something over. So I hope that explanation suits your previous question. Thank you, Chairman.
Thank you, Mr. Sponsor. We will, if I do have the member that you mentioned on my list, but first I also have Chairman Russell. You recognized.
Thank you, Chairman. I just had a question. Is the driver's license affected?
Vice Chairman Ogles, you recognized.
As far as if you're, as far as it getting suspended as like a second, I believe so. Yes, it's counted. If you have a BUI, that would be used as an enhancement or a previous offense, just as if you had a previous DUI.
Chairman Russell, you recognized.
So at a certain point, the TWRA required boating license. Is it the boating driver's license or the driver's license for a road?
Vice Chairman Ogles, you recognized.
My understanding with drafting the legislation that it would affect both. I mean, we're simply stating that if you have one in the water or one in the land, it's being counted as a previous. Right now, if you have a BUI and then you have a DUI, when you get that third offense on land, for instance, it'll only show up as having one previous offense and not two.
Chairman Russell, you recognized.
At a certain point, if you get so many DUIs, your vehicle gets seized. Is that the case with this, or can they seize a boat?
Vice Chairman Ogles, you recognize.
Thank you, Chairman. My understanding is this, the way we've written this, they're being counted as if they were the same. So I believe your answer is yes.
That's all. Thanks.
Next on my list, I have Representative Griffey. You're recognized.
Thank you, Chairman. Thank you, sponsor, for bringing this. So if I get 2 DUIs on land but one on the water, the last one on the water is going to be counted like I got a third DUI under your bill.
Vice Chairman Ogles.
Yes, yes, sir.
Thank you, Chairman.
Thank you, sir. Next on my list, I have Chairman Holsey. You're recognized.
Don't get mad at me.
I've been chatty as well some days. So.
Third offense DUI. I understand that. You lose your driver's license for a year, I believe. But, of course, if you're just driving the boat and you get arrested 3 times for driving the boat, there's no license to lose.
Vice Chairman Ogles, you're recognized.
Thank you, Chairman. Is that a statement or a question?
I think
Chairman Holsey, you're recognized.
I think TWRA can pull the license that allows you to have a boat in the water. It's not a license that allows you to operate the boat, but whatever that little sticker is, I think they can pull that. If I recall talking to TWRA, I think they can pull that license or registration. But of course, that causes other problems. I'm just thinking out loud about a wife who would like to go down and drive her own boat. And I don't know. Listen, I'm with you, and I agree with you, Bill. I really do. If you're driving anything drunk, you know, I'm just having a hard time getting it married up. So I'll leave. Oh.
Thank you, Chairman Holsey. Vice Chairman Ogles, any response to that?
Thank you, Chairman. I appreciate all the support.
Next on my list, I have Chairman Doggett. You recognize, sir.
I'll pass. Thank you.
Okay. Seeing none others, we are ready to vote. Leader Lamberth, you're recognized.
Sorry, Mr. Chairman, I'm sorry to belabor the point here, but it's the boating privileges that are suspended under the BUI, and this would change it where exactly what Representative Holsey said. I mean, regardless of what type of vehicle you are operating, if you were to then get a DUI on the roadway, you obviously have a history of very dangerous behavior, and it would then enhance that DUI. I mean, I think it's a wonderful idea. I don't know why we haven't thought about this previously, but the only revocation that occurs when you're boating under the influence is just their boating privileges. And quite frankly, what one of our judges used to tell folks is that your boating privileges are suspended in the state of Tennessee due to a BUI, but if you go up in Kentucky, our authority doesn't extend that far. And so as a general rule, your privileges are suspended here. And it's very difficult to police because unless that officer sees you out on the water operating a boat and they know that your privileges have been revoked, it's almost impossible to catch somebody that's doing that. But this deals with the driver's license when somebody has been convicted of those boating under their influences, and that's easy to prove. You pull the criminal history, they're able to go and get those judgments, and then that's like anything else. So I am glad that you didn't go down the road to try to say if you get a BUI, it takes your driver's license and everything else. I mean, that's a much harder thing to try to navigate. Just making sure that these count for purpose of enhancement, to me, seems like a good idea. And I did want to ask one question on this to make sure it's in the bill. Would these BUIs, just like DUIs are now, would they enhance a vehicular assault or a vehicular homicide up to an aggravated vehicular assault or aggravated vehicular homicide? If the sponsor knows the answer to that question, or we can go to legal. I want to make sure, because we've had some pretty deadly issues in Sumner County where you get someone that's out on the lake and they're busted several times for boating the influence, and then all of a sudden they get in a car crash and kill somebody. I just think it should be taken into account for that type of behavior.
Vice Chairman Ogles, you're recognized.
Thank you, Chairman. Yes, it would count as an enhancement, is my understanding.
Leader Lamberth.
Thank you, Mr. Chairman, and thank you, sponsor. It read that way to me. I just wanted to double check and make sure that was your intent and ensure that that was in there. Thank you.
So I just wanted to clarify, because maybe I got a little wrapped around the axle, but we were talking about boating privileges, being able to operate your boat, but that's not what the subject of this bill. It's just the number of DUIs that you have. So if you show up, you've had 2 in your vehicle and you've had 1 in your boat, that's going to count as 3. Is that correct?
Yes, Chairman. Thank you.
Is that 2 if by C? Okay. I'll be here all week, folks. Yeah. All right. Very good. Any further questions for the sponsor or for legal? Yeah, that's right. Seeing no further questions, we are ready to vote. All those in favor of sending House Bill 2270 as amended to calendar and rules, please signify by saying aye. Aye. Those opposed? Sir, you had to calendar and rules.
Thank you, Chairman.
Absolutely. And members, we need to take a brief recess. So if we could just take a brief recess. Thank you. We are back in session. Thank you, members, for your patience. Before we head to the next item, I have Leader Lamberth on my list. You wish to be recognized, sir, Leader Lamberth? You recognized? Oh, on the bill. I'm sorry. Okay. Well, the next item on our calendar is item number 3, House Bill 2244 by Vice Chairman Ogles. Sir, you have a motion and a second, and I do have Leader Lamberth on my list that wishes to be recognized.
Mr. Chairman, it's my understanding that there was an untimely filed amendment for us to be able to take up on this bill. Is that accurate?
Yes, sir, that is correct. It was filed with my office.
Yes, sir. And we've got plenty of time, and I hadn't had a chance to talk to the sponsor, but I do have a meeting I need to run to pretty quickly, and I want time to be able to really look that amendment over. This is a fantastic bill. I think the amendment probably strengthens it, but given the fact that we're still relatively early in session with plenty of time, I would make a motion at this time to roll this 1 week, just so the amendment is timely. We can consider it at that time. The sponsor of the bill was vigorously shaking his head side to side as a no on that a while ago. But, Mr. Chairman, I do think that would be best policy. That's what we've done with other bills to make sure the amendment is timely. So, Mr. Chairman, I would make a motion to roll 1 week.
Thank you, Leader. That is a proper motion, proper second. We must dispense with that motion. Any discussion? Seeing none, all those in favor of the motion, please signify by saying aye. Aye. Those opposed? Sir, we roll 1 week. Members, that concludes our business for the day. Thank you very much, and we are adjourned.